Right, we're continuing out of Atlanta, Georgia, the courtroom where Jeffery Williams, young thug, along with 5 co-defendants, are on trial. They are still in their lunch breaks. We're going to have to find out the answer to that rollover question soon enough when they get back at it. We'll take you in there when they return and when Mr. Woody takes the stand. For now, though, let's go back into court. Remember, there were some issues with convictions in Mr. Woody's past, not exactly a stranger to the justice system. So they had to argue about that, find out what's admissible, what's not. Let's go in and listen to that part of the conversation.
For the state's intentions to use any of them so that we could have argument on those. So the convictions that I believe should not come in are as follows. 09 SC 82479, which was a September 1st, 2009 conviction.
For?
That one was for theft by taking.
Okay.
Entering auto and other charges. Oh, well, you know, did he plead to that? Okay. I just want to make sure that he didn't plead to. You know, in all candor, Your Honor, I believe he did plead to giving false info. So for the 09 case, he did plead to giving false information. So they would be able to use that for that limited portion of the fact that he did plead to giving false information.
Yes, that part would be.
That part would be.
Would be admitted.
The next case we have, Your Honor, is 10 SC 87662. And he pled in 2010, but he ended up pleading to a misdemeanor. He pled to misdemeanor theft by receiving. The next is 10 SC 96.
10 SC 96.
938.
Okay.
And that plea was taken on March 7th, 2011. And the charge was aggravated assault and possession of a firearm during the commission of a felony. And then the next one is 12 SC 110195. He pled to this in August of 2013. And he pled to entering auto, several counts, misdemeanor criminal trespass, misdemeanor obstruction, misdemeanor theft by taking. And then on that same day, he also pled to 12 SC 113315. He pled to that on August 13, 2013. And there he pled to terroristic threats, aggravated assault, and battery. Then, Your Honor, he also had another case, which was null prost, which was 12 SC 113001. And another case, which was null prost, 13 SC, this was a re-indictment of that 12 SC case. So the number was 13 SC 120161.
What kind of cases were those, madam?
Those were, it was a possession of MDMA and possession of marijuana less than an ounce. And the 13 SC was a re-indictment.
All right.
And so we believe the admissible convictions, and I can put that on the record, Your Honor, would be 15 SC 136794, in which he pled to that in December of 2018. And the charge was theft by receiving stolen property. The next is 20 SC 176851. And he pled on January 25th, 2022.
I'm sorry, so can you repeat that last time?
Sure. The indictment number or the date?
Indictment number.
20 SC 176851. You're welcome. And he pled to possession of a vehicle with an altered VIN and misdemeanor obstruction of law enforcement officer. Next is 20 SC 176912. And he pled on January 26, 2022. And he pled to possession of a controlled substance, Schedule 1 or 2, with the intent to distribute. And then last is 22 SC 182134, which he pled to on June 29, 2023.
One more time. What was that last number? I'm sorry.
22 SC
2SC.
182134. And he pled to possession of a firearm by a convicted felon. And that was on June 29, 2023. And you're right, there's also a federal indictment. I do not, but he pled to that federal indictment in 2015. And so that indictment would be right. I'll get you the federal indictment number.
Have you shown these the non-qualifying and qualifying convictions to defense counsel?
I have not.
Can you let them take a look at it?
Wow, Mr. Woody Copeland there. I was starting to write down all of but my pen ran out of ink. But I know there's some terroristic issues, a lot of auto theft, a couple of drug issues, some gun possession issues. He actually was sentenced for a gun possession charge in 2018 when he had an assault rifle, took it to the gym, left it on the bleachers. There are kids all over the place. Parents said, there seems to be an assault rifle on the bleachers. And they got him for that, a federal crime. So anyway, Bob Motta's here, Katherine Lizardo. So let me open again the Law and Crime classroom for Professor Motta this time. We're hearing a lot of different convictions, some misdemeanors, some felonies. Which ones are likely to get in and why?
Most likely the felonies will get in. But, you know, really what they are looking at is credibility, right? I mean, what they care about in terms of this witness is being able to establish whether or not he's credible, whether he's somebody that the jury should believe. And like, those are all crimes of violence. Those are all gun possession. That, like, none of those go to, like, you typically like to see like a theft charge or something that relates to honesty. In terms of being able to attack credibility. With this judge, though, I don't know. You know, I hate to harken back to the use immunity thing that we were talking about in the last segment, but I don't know if this judge is going to admonish the witness as to use immunity, because he just flat out asked him if he was going to testify, you know, and I think that could be a real problem down the road at the appellate level if this witness isn't made abundantly clear of exactly what he's agreed to and exactly what it means moving forward. So, you know, in terms of what priors that'll get in, it's going to ultimately be up to the judge to rule on it, but it really should tend towards crimes that have, you know, some impact on the jury being able to believe him in terms of his honesty, as opposed to him having a violent nature.
Yeah, and one of the state attorney there mentioned one of the particulars from 2009 where he had admitted was convicted of giving false information. Obviously, that's a natural. She admits that's going in, but you're right. Yep. It's up to the judge on all these many others. We'll see where that goes. I think they're coming back from lunch, guys. So let's get this break squeezed in. We get back in there for little Woody's testimony as it begins.